Well, the jurisprudence is Carpenter v. Longan. Okay, but the deed of trust document itself, wait, we have some clicking going on. Yeah, there again, in several ways. Okay, but the deed of trust itself is fraudulent without a note. What it explains in it. Otherwise, it's just a piece of paper. There's basically no collateral issued on it without a promissory note. Promissory note is the dog. The deed of trust is the tail. If that deed of trust is not attached to a promissory note, it's dead. Yeah. Yes. There again, page 2, paragraph H, is evidenced by the note.
They wouldn't record the note anyway with the trustee deed because they want to sell it and make money off of it. So they
Correct.
have to detach.
No, notes aren't, they don't record a note. They just record a deed of trust.
But the fact, if it was one concurrent document, if it was truly one concurrent document, you would have to remove the note to record the deed of trust. In other words, you'd have to not just bifurcate, you'd have to destroy one. If it was one document, okay, how could you record the deed of trust without recording the note? You'd have to pull the note out of there. There again, it's evidence it's two separate documents. And because the deed of trust is not attached to the note and it can't stand alone, Carpenter v. Longan, it's dead. We seem to have the same noise. Maybe Cindy's going to... What's that? Oh, okay. All right, so Cindy's going to... Cindy's going to question Bill now. Oh, I'm sorry, guys.
Can you hear me? Is this coming out?
Why don't they record both? I mean,
Okay.
when you have a lis pendens, you have to record it with the complaint. Why don't they record it that way?
Why don't they record the note?
Uh-huh.
Well, what...
You want me to answer that
Yeah.
question? I mean, recording the note, it's a promissory note. The deed of trust is what's recorded. And the reason that they don't record the note is because it's not necessary.
Okay, but hold on for a second. It's actually a more legal question than that. And I'll tell you, that's what nobody gets. That question goes to the foundation of everything that's wrong. I'm sorry, that's what I thought I was explaining. The deed of trust becomes what?
A check.
No, deed of trust. I'm sorry. The deed of trust is what?
It's a lien.
More or less, it's like a mortgage with a lien and title rights.
Correct.
Yes. Then the note becomes what? No, it's a currency exchange, but they stamp the note. Yes. The note becomes, pursuant to the UCC law on instruments, if it says pay to the order of, it can only be one of two things. Check or money order. Okay, so if the note becomes an instrument known as a check or a money order, do you ever record checks or money orders?
No.
You don't. First of all, could that be counterfeit? You could push it to that. The why, I'm not sure you can define the why. Is your microphone on?
Yeah.
Turn it off and let's see if that's stopping.
I don't know what's going on.
Why don't you take one microphone at a time and turn it off?
No, it's one of the electric microphones. It's coming from yours.
Oh,
I don't
to
know
me?
why it keeps coming from yours because I swapped receivers with you and Cindy yesterday because yours was doing that.
An observation. It seems like every time you move your hands, perhaps if you take
hands, maybe off, yeah, right, hook it up to the side.
Because it shouldn't be making any
Because
noise at all.
you're
But this is
interfering
like
with the energy.
making any noise at all. I don't know what's gonna.
Okay, well, I'm fine like this. But I'm not moving.
Try putting it off every time you move your hand.
No, my hands were moving.
It's the jack objecting.
Try it.
Nothing's moving.
What I'm saying is that it's right on the side. And so
I did, and it was doing it. We'll just get on with this. Okay, you know what? I'm not sure I can give you a complete answer on why. I don't know that it matters. I can tell you that the deed of trust and the note must be together at all times. The fact that the deed of trust is recorded without the note, I'm going to do that pin thing. It pissed me the hell out. All it does, it establishes they're two different documents. Don't need to establish why or what for. We're not on that end of it. We established the fraud. We're done. You ready?
Yeah.
Okay.
Mr. McCaffrey, I would like to direct your attention to the adjustable rate note dated May 31st, 2006. Do you have a copy of that?
I do.
All right. And you did your review on that document?
Yes, it's a standard VMP Mortgage Solutions Incorporated document. They're the largest document provider. So it's a standard loan note. Looks to me like it's an MTA index arm, which is, in my professional career, is a very, very predatory loan. But yes, I have reviewed it.
Okay. I have a question. Basically, you're calling this adjustable rate note a loan, and I just want to clarify for you, paragraph 1, do you see where it says borrower's promise to pay?
I do.
Okay. And in that statement there, it discusses loan. Would you read that statement for us?
Yes. Number 1 states, borrower's promise to pay. In return for a loan that I have received, comma, I promise to pay in U.S. dollars, $448,000. In commas, in parentheses, this amount is called principal, comma, plus interest, comma, to the order of lender, period. Lender is Homecoming Financial Network Incorporated.
All right, Mr. McCaffrey, and in that statement, in return for a loan that I have received, what is your opinion, or what is your belief that that statement somehow says that I received some type of a loan?
Objection, Your Honor. That statement under SCOTUS and the Wilson decision is not really, it's not definitive of any concept other than as a plain and ordinary statement for contracts. It's really not incumbent on this contract.
Your Honor, it is incumbent on my examination of Mr. McCaffrey. I'm trying to make a point here about this terminology and what it exactly means. He used the word loan, and I just need to clarify.
Mr. Stewart, I'm going to overrule, and I'm going to allow the
Okay, Your Honor, if I can state on and for the record, really in contract law, we use the term for a loan I have received. It is only now that the plaintiff is bringing up a concept in this contract that she's objectionable to. She did sign the contract,
Your Honor,
stating
objection.
that she did receive the loan.
Objection. What I'm trying to do is clarify his statement to this court about the word loan and what exactly he was referring to, because we're talking about an adjustable rate note. It is not titled loan. So I am trying to clarify where he finds a loan in this document. And if he misused the word loan, I'd like to make sure that we correct that right now.
Who are you referring to misused the word loan?
Mr. McCaffrey.
Mr. Stewart, I'm going to entertain this a little further. Ms. Quintel, I'm not going to continue on with this, though, much longer. Get to the point.
All right. So, Mr. McCaffrey, basically, would it be your contention that in the English language, the past tense may have been used in the sentence in return for a loan that I have received?
Yes, I would say so. It's splitting hairs. If you go a step further, you're more interested in understanding that in receiving a loan, you're more likely to refer to the person who gave you quasi a loan as the note holder. And we cannot establish who the note holder is, so therefore this adjustable rate note could be invalid.
Right.
Your Honor, objection. Facts not in evidence. The plaintiff did sign the document, thereby stipulating that she did receive a loan. There's no facts and evidence that proves otherwise.
Your Honor, I object to that. First of all, we have not any facts and evidence that I have signed any document. We have a copy of a signature, which I have never stated was my signature. My signature would be the wet ink signature. Whatever this signature on this document, it's a copy of something. I don't know if it's cut and paste. I don't know if it's somebody.
Are you saying you didn't sign that document?
This is a copy, Your Honor. I couldn't have signed it. My signature is wet ink. This is a copy of something, but it's not my signature.
Your Honor, invoke Federal 903, 902, 1001. This is certified copy.
Objection, Your Honor. This is
evidence,
not
Your
a certified copy. This is a copy. We do not have certified on here anywhere. He's stating facts that are not in evidence at this point in time. I'd really like the opportunity to make my point with my witness.
But I don't want you to.
I'm going to.
Shut up.
I'm going to overrule Mr. Stewart. Ms. Crentel, can you get to the point?
Your Honor, I just want to ask Mr. McCaffrey, is there anywhere in this document, in this adjustable rate note, that says any kind of language which we can interpret that Homecoming's Financial Network, Inc. actually lent me the sum of $448,000? Or, in contrast, are they really saying that they didn't lend me any money, that I owe them this money for something that I already had?
Your Honor, objection. Relevance. The note is a promise to pay. It's not necessarily incumbent on a previous or a future act. She signed the note. She promised to pay. Therefore, she must pay.
Well,
Her ignorance is not an excuse, Your Honor.
Your Honor, I object to that, Your Honor. I would like to strike that comment, if you may. Basically, Your Honor, I'm still on this point of the word
Hey,
loan.
Stop. You had a perfect opportunity, from what I said, to do what?
I don't know, I didn't hear it. Go ahead.
Okay. I put on the record, and you'll see attorneys do it. They'll say things like ignorance is no excuse, your ignorance, their failure to understand. Just agree with it. What
Okay.
happens if I say that your ignorance caused you to do something when it's obviously the documentation proves that your ignorance is based on my lies?
Okay. Your Honor, I concur with what the defense counsel has said. I absolutely read this, was totally...
Did not understand
this document and what it actually was saying here. And that's my concern, is that this document does not say that I was lent any money. What it says is that I was stupid enough to sign this document claiming that for something I already had, I promised to pay somebody $448,000. And that is in this document. That's what I was trying to clarify with Mr. McCaffrey, was whether or not this document actually says anywhere in here that Homecomings lent me $448,000. And that's what I'd like him to answer.
Bill, I'm going to allow you to answer the question.
Okay. It appears to me, although not certified, that this document, if you want to go into the borrower's promise to pay, number one, in return for a loan, I can't honestly tell you whether you did receive $448,000 without additional documentation that I would have to review.
Thank you.